Some corporate charters or certificates of incorporation include forum selection clauses limiting certain types of litigation against the corporation to certain forums. The Delaware Supreme Court considered the legality of such forum selection clauses in Salzberg v. Sciabacucchi. The 1933 Federal Securities Act governs the sale of corporate stock and other securities to the public. Persons offering securities for sale to the public must file a registration statement making, quote, full and fair disclosure of relevant information, unquote. The Act lays out additional disclosure requirements and allows securities buyers to sue to enforce their statutory rights. The Act permits plaintiffs to sue in state or federal courts. And if a Securities Act plaintiff sues in state court, the case can't be removed to federal court. Other federal laws limit damage and attorney's fee awards in federal court, so Securities Act plaintiffs began suing in state courts. Some corporations responded by adopting forum selection clauses designating federal courts as the exclusive forum for Securities Act claims. The clauses were typically written into a new corporation's certificate of incorporation or charter. Matthew Sciabacucchi bought shares in Blue Apron Holdings Incorporated, Stitch Fix Incorporated, and Roku Incorporated, either during the initial public offering or shortly thereafter. All three corporations' charters contained a Securities Act forum selection clause. Sciabacucchi then sued the directors of all three firms, including Matthew Salzberg, in Delaware's Court of Chancery, seeking a declaratory judgment that the forum selection clauses were facially invalid under Delaware corporation law. The Vice Chancellor ruled that a corporation's charter could only govern the corporation's internal affairs as laid out in Delaware's corporation statute. The statute didn't provide for forum selection clauses, so the clauses were invalid. The court granted judgment to Sciabacucchi, and Salzberg appealed to the Delaware Supreme Court.